When I meet people, people often ask me, well, what is regulation? Everyone knows what crime is. So I wear two hats, crime and regulation, but they actually overlap more than most people realise. I think most people here today are professionals, which means we are governed by professional bodies. So we have to comply now not only with legislation, but also rules and regulations. We are governed by the Solicitors Regulation Authority, and sometimes I feel as though I can barely breathe without reporting the fact that I've done so to them. They're very, very important, and I'm often surprised at how many businesses, big businesses, don't know exactly who they are regulated by. And you should all know, and if you don't know, you should go and find out, because they have vast powers. Sometimes their powers even exceed the powers of the police, and they can come in, they can investigate your business. They often do so if somebody complains about you. Some of the most common ones are there, the General Medical and General Dental Council. I've acted for doctors and dentists that have done things that they shouldn't have. One of the better known ones there is the Department for Business Enterprise and Regulatory Reform. That's the old DTI, so I've done lots of DTI investigations. The Environment Agency are busy at the moment. They're doing inspections on building companies to check they're burning the right kind of wood or not burning the right kind of wood. So I've done lots of those work. And I've just put there at the bottom that they regulate not only your professional life, but also your personal life. So I often come into contact with these, not only say the Financial Conduct Authority if they're investigating a financial advisor, but also if you've been up to no good in your personal life. So I've represented lots of doctors, dentists, accountants, lawyers, who say, for instance, have been convicted of drink driving. They're not only punished by the criminal courts, but then they are hauled up before their professional bodies to explain themselves. And the SRA, for instance, if I did something that they didn't like very much, they could strike me off and I would never be able to act as a solicitor again. So as I say, they've got vast powers. So I spend lots of my time dealing with these people. One of the better known regulators is HMRC, who you will all know, and HMRC, I expect, are going to be very, very busy in about 12 months' time. I say that because they're notoriously slow to prosecute. And it's important that people know that, because just because they're not knocking on your door in 6 months doesn't mean you're out of the woods. It just means they haven't got to you yet. So furlough fraud, has been said, is topical at the moment. You will see lots of reports about it in the press. So I'll try and just keep to the facts. It's a huge topic, really, but it arises out of the coronavirus job retention scheme, the furlough scheme, and associated grants that go with it, such as the one I've listed there. Inevitably, when new schemes come about and when they rush through, it's open to abuse, and these schemes are expected to be a magnet for fraudsters. There's 1.2 million companies taking advantage of the scheme, with the cost to the Treasury of £35.4 billion. It's quite phenomenal, and there's 9.4 million furloughed at the moment. Now, 34% of the people furloughed have been asked to continue working. And if you think that's 1 in 3 people are breaching the coronavirus job retention scheme, it's huge. This week I saw HMRC publish that they expect 5 to 10% of furlough monies to have been wrongly awarded, either through error or fraud. I would be amazed if the figures are that low. I think they've underestimated it hugely. Why do I say that? Well, one of the reasons is HMRC were very, very quick to implement furlough, which was great for those that needed it, but they were equally quick to set up a whistleblowers hotline so that anybody suspected of committing fraud, you could report them anonymously over the telephone. And again this week, HMRC say they're looking into 27,000 high-risk cases. Again, I expect that number to rise. That means 27,000 businesses up and down the country can expect a knock from HMRC anytime, asking them to see the paperwork in respect of the claims they've made. The whistleblowers in June reported 1,900, and by September it was 8,000. It's just increasing all of the time. I have cause to speak to customs officers fairly regularly because some of my clients are prosecuted by them. And at the moment when I speak to them, it's very difficult to get hold of them. And they're telling me it's because all the officers within HMRC are being taken off their day jobs and redirected to look at furlough. and to look at the benefits that people are claiming. So they are behind the scenes looking at all these people making these claims, and you'll see the first arrest came a couple of months ago, widely reported. They went in heavy-handed, dawn raid, froze their assets, seized the computers. They weren't messing about. Yep. So just to give some examples of furlough fraud, forgive me if you all know what this is, but there's a strict requirement that employees must not, either voluntary or at the behest of their employer, provide a service for their employer or generate any income whilst furloughed. In essence, you just can't work. So some examples of furlough fraud that I've seen are employers asking employees to continue working whilst furloughed. That's clearly in breach of the rules. Making ghost claims for non-existent or former employees where they've got their personal details and are able to falsify claims. Oh, forgive me. Claiming furlough without the employee's knowledge, misrepresenting the hours worked, falsifying documents to obtain the business interruption loans. I think that's going to be something HMRC start to look at later. And this is a biggie as well. Businesses that have rode out the business longer than they would have done, they've continued to trade when otherwise they'd have gone bump. So they've used the furlough scheme to keep going. That's going to be frowned upon, I would imagine. You may have seen in the press that Mike Ashley, the owner of Sports Direct and House of Fraser, he's allegedly asked his staff to continue to work, to not clock on and to work as volunteers. So if you think big PLCs are doing this, what are the little companies doing? And then anecdotal evidence. I know at the start of the coronavirus pandemic, I did a couple of blogs. I've stopped doing them because I was inundated with people asking stupid questions like, can I go round to my granny's for tea, or that sort of thing. But as a result of that, I got all sorts of inquiries, and surprisingly, I got quite a few inquiries from professionals. One such person was a solicitor who shall remain anonymously, saying he had been working throughout the pandemic whilst he'd been claiming furlough, and what should he do? And my answer was, well, he should stop doing that immediately. And he was claiming that the furlough scheme was too complicated for him to understand. And whilst I appreciate it's complex, I don't think the court or HMRC are going to accept that a solicitor can't work his way around the scheme. So when you think professionals who should know better are doing it, what are those doing who really have probably struggled to keep up with the government's guidance? So the penalties are huge, and they can be civil or criminal. I'm sure you all know directors and company officers have statutory duties. They have to exercise reasonable care, skill, diligence, promote the success of the company. And in addition to that, they've got fiduciary duties to maintain business reputation, act in the interest of the employees. Now, that's important because HMRC have come out and said they're going after directors' joint and several liability. Forgive me if you all know what that means, but in essence what it means, you can't say, well, the finance director took care of all this and I knew nothing about it. HMRC have specifically said they'll take you all down. They can also come after you for personal liability. So the civil penalties are obviously less onerous than those of the criminal courts, but they've already said they'll be imposing 100% tax charge on any payments wrongly received. There'll be financial penalties, and directors' disqualification proceedings will undoubtedly follow. If the courts find, or if HMRC think you've been acting dishonestly, then inevitably criminal penalties follow. I've listed just some of them there because the Finance Act have just been passed. It hasn't made a specific offence of furlough fraud, but it's likely to be captured by some of those offences there. And I've just put some of these sentencing bans so you can see how serious the courts look at tax evasion these days. And the third thing that's equally important for companies to think about is the reputational damage. I would imagine that HMRC are going to see this as nicking money from the charity box. It's an unsavoury kind of offence. They've already said they will be publicising companies that are investigated. So that's something else you have to bear in mind. So the tools at HMRC's disposal are huge. As I've said, HMRC are properly resourced, and they've set up investigation teams to reassure the public that all steps have been taken to reduce any fraud. because they want to recover taxpayers' money. At the end of the day, it's not come on a money tree, has it? It's come from our taxes, and they will be playing on that. They've said they will be looking at unintentional breaches, but also dishonesty. So we have to consider what they think will be reasonable. So we need to bear in mind at the moment what is reasonable during this unprecedented time. Can it be reasonable for companies to have got everything 100% right during the period of confusion, stress, illness? The scheme's complex. I don't understand it fully myself. I know our employment team have been very, very, very busy with inquiries about the scheme, and the flexible furlough, I believe, is very complicated. So it's open to see whether the courts will take a firm view, or will they expect companies to already have procedures in place, because companies already have onerous legislative and regulatory requirements. So going back to the list of offences that I gave and as an example on there, was tax evasion. That's failure to report tax evasion, and that's actually a strict liability offence. That was passed by an Act in 2017. HMRC published these guidelines here because if you fall foul of this legislative provisions, failure to report tax evasion, the Crown don't have to prove any dishonesty. It's strict liability offence. So when you're making any decisions, there's 6 points there that should be at the forefront of your mind. So the courts may say, well, HMRC have been dishing out this guidance for many years, and had you followed your guiding principles, which you should be following anyway, then you shouldn't have fallen foul. So it'll be interesting to see how the courts interpret people investigated for this. So who's at risk of prosecution? The Finance Act has only just been passed, July of this year. HMRC have said they're going to be lenient with people who have made errors in judgment, who have made mistakes. We expected them to come out and give businesses 30 days to come forward and hold their hands up to any mistakes. They've actually made that 90 days, but it ends fairly soon on the 20th of October. So this 90-day period is an amnesty. So if as a business you have claimed sums that you weren't entitled to, or sums that you've discovered you weren't entitled to, the theory is you can go to HMRC and they will take no action against you, providing you pay the money back. Whether they employ that in such a simplistic fashion is yet to be seen, but they will certainly be looking at deliberate and dishonest conduct, or misunderstanding, or error. So dishonesty almost certainly will follow a criminal prosecution. What is dishonesty in criminal law? Well, it's an objective test. The test is, would an ordinary reasonable person consider what you have done dishonest? And that's what should be at the forefront of your mind when reviewing any decisions that have already been made. So we know HMRC are coming knocking on doors very soon, asking for companies to show their internal decision-making process in applying for furlough fraud. First of all, they're going around the £27,000 that has been a result of the whistleblowing exercise, but thereafter they have said they will be conducting spot checks. So what can you do to protect yourself? Well, every business who's made a claim under furlough should do this, if nothing else. Carry out an internal audit. Satisfy yourself that you are entitled to the monies you've received. If an error has been made, then think about approaching HMRC before they approach you. Depending on the size of the company, resources, etc., you may think it better to have an external body to come in and audit. Solicitors will do that, accountants will do that. That gives you an obvious extra layer of protection. Furlough came in, didn't it, all of a sudden, and everybody was running around wondering what they were entitled to and what they needed to do. So board meetings weren't held in the same way around a board table with someone taking minutes. But all company officers should know that any decisions taken by directors ought to be recorded. And again, I'm always amazed at how many businesses are run on WhatsApp or on emails with no proper records anywhere. So you should revisit any decisions made, even if they were a telephone call at 10 o'clock at night. Make a note of it. print your WhatsApps off, print your texts off, get yourself together a folder with all the decisions you made, why you made them, who was involved in that decision-making process, any professional advice that you took, so that if and when they come knocking, you can say, if I've made a mistake, this is why I've made the mistake. There was no dishonest intent here to defraud anybody. So if you're sat there thinking, okay, well, I probably shouldn't have made that claim, or I know somebody who's claiming and they shouldn't have been, I wouldn't advise you go running off to customs, holding your hands up saying, I've done something wrong. Seek some advice before you do that. Customs have you may know, a Code of Practice 9 process, which is when HMRC kick off an investigation and suspect tax fraud. Some of my HMRC contacts have told me this is what they're going to be doing. I don't know if that's right or not. But a COP 9, basically, if customs approach you and ask you to admit or deny doing something, if you make an admission and give full disclosure, you get immunity from criminal prosecution. So they can be a very, very useful tool. Sometimes we as defence lawyers will approach HMRC and see if they'll let us make a COP 9 on the promise that we won't be criminally prosecuted. So it's quite an attractive procedure, but it's not a simple one, and you have to be very careful how it's dealt with, because full admissions need to be made, disclosure, and it's warts and all, why you did it, who was involved. Any false statements will be used against you and they will prosecute. So as I say, I wouldn't advise running off to customs. If you know you've done something wrong, do it through a professional who knows what they're doing. The other thing that I think is going to be risky are the whistleblowing policies. Many companies do not have these policies in place, and it's a huge error. We'll all know someone. Well, I'll give my example. So I was very, very busy at the start of furlough. All my secretaries went, so you feel as though you're running around doing the job of 3 people. Meanwhile, I look over my garden fence and my neighbours with their feet up drinking wine on a sunny afternoon, and it sticks a bit, doesn't it? So we're going to have disgruntled employees, and disgruntled employees like to report their employers, and they can do so anonymously on a phone call, and that is what will have been happening. And I bet a good proportion of the 27,000 reported have come from disgruntled employees. So check your whistleblowing policies, ensure that employees know how to use it. If you hear whispers of fraud at the water cooler, make sure staff know where they are to report. Have an open culture, have appropriate reporting lines so that it can be dealt with in accordance with the whistleblowing procedures. I'm not an expert, it's employment law, that really, but it's something that I come across businesses that don't have adequate protection in that area. Furlough fraud documentation is like most business records. We have to keep them for 6 years, but I've just put a warning there. HMRC can go back far, far, far in excess of 6 years and up to 20 years if they suspect fraudulent behaviour. The other thing that I'm always surprised that people don't have is, I don't know if there's an official name for it, I've called it a dog on raid policy. But if customs do come knocking on your business at 6 AM with warrants, do you know what to do? Do you know what your rights are? Most people don't. Have a solicitor available to come down and supervise the search, get copies of the warrants, get them to your solicitor. Make sure you don't answer any of the questions, say nothing, shadow the officers if they won't wait for your solicitor. And this is a really important piece of advice, again, that I see companies not taking advantage of. If you have communications with lawyers, you more often than not do not want that getting in the hands of the police or customs or any of them. Certainly with my clients, my criminal clients, if I take their instructions and send it to their house and the police come knocking, we do not want the police getting their hands on our documentation. So any legal correspondence, put it in a box, put it in a folder and write across it legal professional privilege, because they cannot touch that, they cannot see it. So it gives you a bit of protection. There's complicated steps afterwards, which I won't go into, where they may try and get that information. But just anything sensitive, put it in an LPP box. And then I've just noted there mitigation. again, you know, memories fade fast. Decisions have been made under pressure. If you had a lot going on in your life at the time, pressures of work, personal life, perhaps you had a family member who was suffering with corona, all of that needs to be just written down somewhere so that it's to hand when customs come knocking. And then this is the end really, but I've just highlighted some other areas of risk that may give companies exposure as a result of furlough fraud. So the Proceeds of Crime Act, many of the offences under which you could be prosecuted for furlough fraud attract a confiscation order. So if you are convicted of some of those offences, you will automatically be subject to confiscation proceedings, and that means that HMRC's starting point is everything that you have in your bank, in your house, any assets that you have are the proceeds of crime, and the burden is then upon you to prove otherwise, and it's a very costly exercise, very laborious exercise. And as we've already seen from the one arrest that's been made, they came in with freezing orders straight away, seized all the IT equipment. So it's not just the proceedings themselves as ancillary orders that are available to the prosecuting authorities. And then I don't know if you saw it on the news, I saw it on the late news last night. Health and safety prosecutions are going to be on the increase, which again is something that I have expertise in. So as an employer, you have duty of care to your employees. Make sure you've got the right risk assessments in place. Make sure you've got the arrows on the floor, posters on the wall. I'm sure most people are, but again, small businesses sometimes overlook these. Have PPE, have hand sanitizer. And on the news last night, I live in Bolton, you can probably tell with my accent. So we're in lockdown again. And HSE, the Health and Safety Executive, reported last night that they would be spot checking businesses in Bolton. So there'll be businesses now having visits. And if they don't have these very simple things to implement, they may be prosecuted by the HSE. And again, they're pretty powerful in their powers. The employment law I've kind of touched upon, the whistleblowers, but just to say that if a disgruntled employee does make a complaint against you, they will attract protection under employment law legislation. So if they have a reasonable belief that a breach has occurred, you can't sack them, and they will be protected. And in fact, sacking them is the last thing you probably want to be doing. And then again, I've touched upon it, but the risk of insolvency. Many companies, I know some, just off the top of my head, that were in difficulties and have used the government money to keep going. They've just prolonged the inevitable. And when they do go bump, then the directors will inevitably come under scrutiny as part of the insolvency process. That will be reported to HMRC, and prosecutions again are likely to follow. So that's it from me. I hope that's been of some use, and if anyone's got any questions, I'll be happy to answer them.